Good afternoon, dear Professor Hahn, dear Mr. Linas Vilys. Welcome, dear ladies and gentlemen. As the Executive Director of the Baltic German University Liaison Office, I would like to welcome you today to our scientific afternoon, Social Security Systems in Europe. And at this moment, I would like to thank the Mykolo Romerio University and especially Associate Professor Dovile Sagatiene and Professor Lina Mykolo for their cooperation in organizing of this event. But now I would like to very briefly introduce to the Baltic German University Liaison Office, and it aims to function as a scientific bridge between the Baltic states and Germany. And with our annual project competition, we aim to support projects that initiate and strengthen scientific cooperation between Lithuania, Estonia, Latvia, and Germany, and moreover to provide also a platform for scholars and scientists to discuss topical issues of science by organizing scientific events, like today. And for this reason, we have two competent speakers from Germany and Lithuania. They have been selected to discuss the highly relevant topic of social security. And we will begin with the lecture of Coordination of Social Security Systems in Europe by Professor Erik Hahn. However, before we start, I would like to introduce him to you. Dr. Erik Hahn is a professor of law at the Zittau Görlitz University of Applied Sciences, a permanent lecturer in a course of study at the International University of the Technical University of Dresden, Deputy Director of the Görlitz University of Applied Sciences, Institute for Health and Age, Work and Technology, co-director of the Master's Program Medical Law at Dresden International University, and visiting professor at the Faculty of Law of Riga Stradiņš University. And before joining the university as a professor, Erik Hahn was also a judge at the Social Court in Dresden, and today I have heard it also, since week he is again a judge at Court for Social Security. Yes, thank you for finding time with all these positions and coming here to Vilnius and joining us here today. And now we are pleased to listen to your lecture. Yes, please.
Thank you. So I have to change. So I have some slides for you. So, okay. Yeah, thank you for the introduction and for the opportunity to be here and to speak about a very interesting topic as well from my perspective, sure, but I know it's not in the main focus on typical law studies, but yes, if you widen your scope for future working opportunities, so I think there would not be an opportunity to go anywhere without be influenced or affected by this principles. So I have some slides, but I will talk about the basic principles. This regulation. The idea is guaranteeing the free movement of people is one of the fundamental achievements of the European Union. You maybe know the freedom of movement of workers, and from my perspective, and I think it's the same from your perspective, it's not possible to look for this freedom without guaranteed securance for your social rights. Migratory movements in the European Union would be unthinkable without answer to the question of this kind of social security, and the coordinating social law of the European Union makes, of course, this makes a significant contribution to this. In the following, it's a primary legal basis will be discussed from my position. Then after that, the scope of the coordinating European social law must be defined, and the governing principles are then to present it using the relevant regulations. And a part of this will be a look into the, I call it maybe kind of conflict law about the applicable regulations. So at first, it's highly important to know that the European Union, based on law, which among other things pursues the goal of social progress and has itself the task to promoting social justice and social protection, as you can see it here in the Treaty of the European Union. However, this doesn't mean that there should be a uniform or even common social law in the European Union, because the reason is really simple. There is no competency for a harmonized social security system. It's therefore necessary to determine at the level of the member states which persons are included in the social security systems applicable there, what extent of social protection the person enjoys there, and under what conditions which benefits can be expected, and how this system is financed and, of course, further developed. It would be, therefore, a wrong way to speak about a kind of a European social security union or a European welfare state or anything else. It's more a coordinated system between the national legislations. So, we have to think about the principle that with the creation of the European Economic Community, the precursor of the European Union, the mandate was given under primary law to coordinate the different member state systems of social security in order to ensure their compatibility for social security aspects. The fact is, this task is not minor, of course, but essential importance for a real success of European integration process. It's that the first regulation, or one of the first regulations of the EEC, were already dedicated to this goal. I think the third or the fourth regulation from the EEC were about social security coordination. Today, the legislative competency can be found in Article 48 of the Treaty of the Function of the European Union. According to this, a system of coordination needs to be created that makes it possible to aggregate up the times worked by employees and self-employed persons in the member state, and then to transfer the benefits to another member state. The main instruments of coordination at the level of secondary law are so-called basic regulation, or you will hear more about it's regulation number 883 from 2004, and the associated implementing regulation number 987 from 2009. The latter is primarily aimed at the administration of the member states, but both, I'm sure you know it, both are regulations, and because of that, these regulations are self-executing, and therefore they do not leave the member states any leeway for deviating regulations. So let's talk about the scope. What's about the scope of this coordination system? The regional scope for the application of the coordinated social law, you heard I say coordinated, not coordination social law, coordinated social law between the member states, extends primarily to the territories of the member states. It's also extended to Iceland. I can show it here, to Iceland, to Norway, and to Liechtenstein by the agreement on the European Economic Area, and the same principle applies to Switzerland due to the agreement of the free movement of persons between European Union and Switzerland. And of course, as a result of the Brexit, the relationship between European Union and United Kingdom must be re-regulated by a separate agreement, Brexit agreement, and this Brexit agreement also includes, among other things, a protocol on social security, and this protocol largely adopts the basic principles from the regulation 883 from 2004. Maybe it's interesting to know that in contrast to that, the coordination of social security between, for example, the European Union and Turkey is based on a separate association agreement. It's from 1960s. I mean, 1963. It's not quite the same, but the principles are more or less quite similar. So the regulation 883, you can call it also basic regulation because of this additional regulation, applies to all European citizens at first, of course, and it also applies to their relatives and survivors regardless of their nationality, if the claim can be derived from a European citizen. In addition, refugees and stateless persons residing in a EU member state were also included into the system by the basic regulation. In addition to this, a regulation from 2010, number 1231, also brings third country nationals within the scope of the basic regulations if they are legally reside in a European member state. But in this case, it is required that the cross-border situation must be between two European member states. So it's not possible to applicate the basic regulation if you come from, for example, Egypt and you move to France. It's possible that you are Egypt citizen, but to applicate the regulation, you must move from France to Germany or from Lithuania to Sweden or anything else. So, what's about the material scope? According to Article 3, I can show it here to you. Classic social security benefits, so-called modern social security benefits, so for example family benefits and non-contributory cash benefits are covered by the scope of the coordinated social law. It's irrelevant whether the social benefit is assigned to the social or the tax system in the applicable national law. So, for example from German perspective, in Germany we have the so-called child benefit, and this is a kind of anticipated tax refund to the parents, separate in 12 parts and paid back to the parents. This is a benefit from the tax system, but from the perspective of the regulation, it's a benefit for social security, and so this regulation should be applied. However, the catalogue mentioned in the regulation makes clear that the relevance of the regulation to the labor market, and this is not surprising since the coordination is ultimately a consequence of the freedom for the movement of workers under the primary European Union law level. On the other hand, it's irrelevant from which source the social benefit is financed. So if the money comes from the tax system or from the social security system, that doesn't matter. In addition, we have a very important principle. It's regulated in Article 9 of the coordination regulation that provides a so-called notification procedure. According to this, the member states are obliged to notify the social benefits that they believe fall under the coordination regulation. With regard to the named services, you have a kind of legitimation for the affected persons, but however, if some benefits are not named, not notified, it's not possible to cover them out if they are legally under the regulation. So it's not possible to bring it out of the application. Explicitly excluded according to Article 3, paragraph 5 of the coordination regulation are services of social and medical care, but in the sense of basic security or basic income. So just tax funded, yeah, and services, also services which member states pay for a liability for a personal injury. For example, a very important case at the moment in Germany, a payment for vaccination damages. These payments are not under the regulation. These are typical state and national benefits, and so it's not possible to coordinate them. So But in the Article 3, paragraph 4 of the basic regulation, in conjunction with Article 17, the regulation also applies to so-called special non-contributory cash benefits, which characteristics are both. So they are social security and a kind of social assistance, like a basic income at the same regulation, if these benefits are notified by the member states. So the member states are free to decide if they want to notify this social assistance benefits, and then they can bring it under the regulation. So you can. Okay. Let's go further to. I just want to talk about some key principles of the regulation. Coordination social laws governed by several key principles, for example, non-discrimination, requirement of aggregation, application of just one social law, as we discussed some minutes ago, harmonization of facts, and so I will present you some basic information about this. So at first we will have a look into the principle of non-discrimination. One of the central principles of the coordinated social law is the so-called requirement of non-discrimination. It's also explicitly, I have to look, regulated under the primary European law level at Article 18 of the Treaty of the Functions of the European Union, and it's explicitly named also in the regulation under Article 4. What is the consequence? You have to know both direct, so-called direct discriminations. Direct discriminations are discriminations discrimination which is directly linked to the nationality. So you are out, for example, a very famous case from the last year, you are out from insurance from Latvia for sickness, for example, just because you are not a Latvian citizen. Yeah? The discrimination is mainly and only focused on the nationality. That's a so-called direct discrimination. And also, indirect discriminations are prohibited, but the difference is that indirect discriminations may be justified by objective considerations independent from the nationality of the person, as long as they are appropriate to the aim pursued from the legislation. As I told you, for example, the case from Latvia, I can tell you some information about, so you can imagine what was the task for the European Court of Justice. There was an Italian person that moved to Latvia, and he was family insured in Italy, so he didn't pay for the insurance. I think it's the same. Maybe here in Germany it's the same. If you're family insured, your husband maybe or your wife is working, you're not working, you are family insured for free. So you're inside the insurance, but you not have to pay for it. And so this person moved to Latvia and requested for access to the Latvian healthcare system, at first to the Latvian healthcare insurance, but this was denied, fundamentally denied, with a view to the so-called Directive 2004-38, is the directive for the freedom of movement in the European Union. Since a stay of more than 3 months as a non-active person, that means a person who is not seeking for a job or is not working, is linked to the ability to provide for its own financial needs. If you're not able to provide your own financial needs, there's no freedom of movement. You can be sent out after this 3 months. Also, if you are a European Union a citizen. The European Court of Justice had the task to balance out these principles, non-discrimination and not unlimited freedom of movement if you're not able to found yourself. And he decided that Latvian state is obliged to include the Italian guy into his insurance system, but at the same time the court gave the possibility to make this dependent from a future payment for the insurance in the future. So so it's possible to go in at that time, but the Italian guy is forced to pay to stay in the insurance system. So that's one case. Another case, for example, a German case we have a special regulation for basic income. Basic income, as I already told you, is included if it is notified, and the German state notified it, but they exclude persons from foreign European countries if they are only in Germany for seeking a job. So they are out in the first six months. So the question was, is this a kind of, forbidden discrimination? And the European Court decided also in case of balancing these principles that it's allowed to sort them out from these benefits. Also, if your own nationals are in the same situation, are in the position to receive these benefits, if you are not able to finance yourself. So it was a decision to balance out this directive for free movement of workers and work seekers and the idea of a non-discrimination. So non-discrimination doesn't mean it's completely forbidden to discriminate, but you need appropriate measures. So a next very important principle is the so-called principle of equal treatment or alignment of facts. I have to go further to this slide. It's a special form of a prohibition of discrimination, this idea of equal treatment. In the harmonization of facts, it's regulated under Article 5 of the regulation, and according to this, functionally equivalent facts or events, for example, an accident at work, or a reason to become ill, or events that have occurred in another European member state, are to be treated as if they had occurred domestically. That's a very important principle. So, for example, periods of employment completed in a foreign European member state that are required for a kind of unemployment insurance, for example, should be considered here for benefits under your national legislation. The next principle is the principle of aggregation. What does it mean? Aggregation is regulated also on the primary European law level, as I told you in Article 48. Where is it? Here is it. Article 48. It's also the basic for this principle of aggregation. There's the principle that the national states and member states are forced to aggregate these benefits and times. I have to go back. Sorry. So. And this is initially achieved on the secondary European law level in Article 7 of the basic regulation through the so-called, it's called aggregation principle of equal times, so we can call it. Periods of insurance, periods of employment, periods of residence, periods of self-employment, for example, completed in another European member states are relevant to acquisition, they are relevant for maintenance, they are relevant for the duration, and of course also for this resurgence of a social security benefit. For example, in Germany you can receive a kind of sick payment after the period you didn't receive any payment from your employer, then you will receive a sick payment, but not up to the end, not forever. Yeah? And the time you receive this sick payment, for example, in Germany, and the time you receive it here in Lithuania, these times will be aggregated. So it's not possible to move or to cross border to extend the period, of course. Yeah? This is achieved by adding up all foreign domestic times, and the consequence of this aggregation principle is the portability of time. So you can go to a foreign country and you take the time you fulfilled in the past with you, and of course the avoidance of disadvantages as a result of a cross-border movement to another European member state. So the next is the so-called, in my perspective, the most complicated principle. It's the principle of export of benefits. Yeah? We already talked about export of times, but now we have to think about what's about a claim. Yeah? You received, and now you want to go to another European member state. This is one of the most important principles, is regulated under Article 7 and in special regulations further in the regulation in the parts for the special insurances. So we have special part for healthcare insurance for working accidents, for retirement, and so on. And so they are deviating principles, but the main principle is regulated under Article 7 under the principle of so-called ban of place of residence clauses. Yeah? With a perspective to the national social law, of course. The provision, and thus also the portability of services, must not depend on the question of where the recipient of the benefit or actually lives. That's the idea. This applied without restriction to the so-called cash benefits. Cash benefits, yeah, just payment, just money. Under the idea of the European Court of Justice, cash benefits are a sum of money. Yeah? They are paid evenly, they are paid recurrently, and they are paid without any proof of the use for this payment. And these cash benefits serve as a compensation for reduction of the standard for your living, your living standard. For example, in a case of illness. Yeah, you receive treatment from the doctor and the payment as a compensation. That's the difference. In this case, it's very simple to export such benefits, because money is money, and you can transfer it via banking, by banking payment. It's no problem. The bigger problem is the so-called benefit in kind. Yeah? That's different. Because their provision depends on the existence of a country-specific providing system. So, for example, in Germany, sorry, I took a lot of examples from Germany and Latvia, maybe little framing at the moment. In Germany, we have the so-called SHI accredited physicians. So these are physicians. They are accredited by the statutory health insurance system. And if you are in this system, you are allowed to treat outpatient. That's the idea. If not, you're allowed to treat, but you are not allowed to send your invoice to the insurance. That's the problem. And exporting these kind of services, it's not possible, because if you want to export this kind of services, you need to export also the service provider. Yeah? So you have to call your doctor from Lithuania, please come to my holiday to Spain and treat me. That would be the consequence. And this is largely impossible, so that the coordination law relies on an alternative, and that is called benefit in kind support. What does it mean? Yeah, you have a claim to receive benefit in kind, but from your host member state. According to this, benefits in kind are provided in the member state of residence by the local institution according to its legal principles, of course, because you need the institutions. You cannot say you need institutions maybe from German law, also in Poland would not be possible, but at the expense of the responsible, or let me call it a competent member state. Yeah, it's the state where you're insured. Normally, there are some difficult situations. Maybe we can discuss it later. But normally, the competent member state is the member state where you are insured. As a result, benefits in kind can only be exported if they can also be provided in the member state of residence by the local institution. So, if not, it's not possible. Yeah, and since this, some member states, also Germany, in a lot of times, they try to classify types of benefits, cash benefits, normal cash benefits, that they are a kind of a benefit in kind. Just payment to receive later benefit in kind. So to avoid the ability to take them to pay it in another country. For example, in Germany we have a payment for care. You are free to decide if you want to receive a care in a natural way, yeah, maybe from a hospital or from a special care service, or you want to receive care service from your family or from your neighbor, and to earn some care payment, care benefit, and then you are free to use this money for whatever you want. But German state said this is a kind of cash benefit in another form. So it's not possible to go to Spain and transfer the money there, but a European Court of Justice said no, it's payment. It's just payment, it's just money, so it must be exportable. Yeah, that's the result. Yeah, and the European Court of Justice has opposed these attempts several times in recent years. Also a lot of German cases. So then we have the prohibition of the accumulation of benefits. What is the idea? So it could be possible that you fulfill insurance periods in more than one state, and so the consequence could be that you receive, for example, cash benefits for care from France because you're a French citizen, and from Lithuania because your host member state is Lithuania. And the idea is to avoid disadvantages. But the idea is not to aggregate benefits to an unlimited level. So should the coordination principles lead to different benefit providers having to grant benefits on the basis on the same insurance period? This is ruled out by Article 10 of this basic regulation. So. Do I have 5 minutes? Yes? Okay. So let's have a short view into the principle of the, from my perspective, very important principle of the applicable law. Since neither the European primary law nor the basic regulation or the implementing regulation, as I already told you, established a uniform social law statute, no uniform social law, and as well no uniform social law statute. A central part of the coordinating European social law is to determine the applicable law. In this respect, it's a kind of conflict law. Maybe your students know it from the private law sector, from Rome I regulation. It's a kind of international conflict law, private international law, and it's the same here in this basic regulation. Basic regulation has the task to decide what is the applicable national social law. Because one key principle from this regulation, it's regulated under Article 11, is that this regulation stipulates that there's only one legislation of a European member state shall apply. Yeah? No differences, no. It should be avoided that the question if you are injured is is to be answered after French social law. And the question if you fulfill the waiting time is maybe answered under Lithuanian law. And so the principle is only one national member state law should be applied. Which legal system is to be applied is essentially determined in the chapters of the various branches of insurances, so we cannot discuss it at all here. So if you want to know who's forced to pay for my injuries and what law is applicable, so you have to look in the chapter for the healthcare insurance, for example, and then you can see it will be provided from the host member state, but with respect to its own national regulation. Thereafter, the law of the place of work, after Article 11, subject to deviating special regulations, is the leading point. This is also not surprising in view to the underlying freedom of movement for workers. What was the idea, the fundamental idea for this regulation? Recently, however, more and more questions have been asked about to deal with new work phenomena. For example, think about digital working platforms, where is the place of work? Or, for example, think about the increased demand for home office work due to the corona pandemic in the last years. So, a very important deviation from this principle, you can see it here, is the case of posting employees. If you didn't have such a kind of deviation, otherwise a change in the applicable law will intervene here, even in the case of so-called short-term activities abroad. And the principle is, at least as long as a period of maximum 24 months, if this period is not exceeded, the social law that applies in the employee's country of origin principle remains applicable. Also, you're posted. This exception applies even if the employee, so a decision from the European Court of Justice, was solely hired for a posting, but in this case, it's necessary that the employer develops a so-called significant economic activity at the place from which the posting takes place. So in this case, the proof of insurance we already talked about is provided by the so-called A1 certificate. Maybe you have the same need if you want to go abroad. Another deviation, last deviation, Article 13 of the Basic Regulation, also regulates a very special case. This concerned the coincidence of several activities in the different countries. So I can, for example, talk about my case. As you heard, I'm a professor in Germany in a civil servant contract, but at the same time, at the moment, I'm a guest professor in Riga. So I have a working contract with the Latvian state, and in order to avoid multiple applicable national social security systems, here Article 13 from the Basic Regulation focuses on the place on the main working activity, and I think that would be your topic. Yes, it will be your topic. Perfect. Okay, so yeah. 43, perfect. I think it's a good point to finish. Yes, I hope I could give you a little insight to European social law coordination system, and I thank you for your attention. And maybe after that we have the opportunity to discuss some questions. Thanks a lot.
Thank you for your lecture, Professor Hahn. So yes, you will have possibility to ask your questions after the second presentation. Now I would like to introduce you our second speaker, PhD candidate Linas Vilys. He is graduated from the Faculty of Law of Vilnius University in 1998 and obtained the qualification of a lawyer And from 2000, he's working as an attorney, but also since 2008, he's also a lecturer at Mykolo Romerio University. Thank you for joining us this afternoon. And the floor is yours, please.
Yes. Hello. Thank you very much, Mr. Erik, for a nice presentation about the principles of the coordination. And finally was said about the Article 12 and 13 about regulation number 8083. And I will start further about that regulation, Article 12 and 13. It is route of my presentation. It is about the court decisions in Lithuanian administration courts. The practice about the Article 12 of Regulation 8083, and I would like to say that last 2 years was not so much decision in High Supreme Administrative Court of Lithuania, but almost all of decision was around the applying of the Article 12, Article 13 Regulation 8083, and one kind of dispute was in the court. The topic of the dispute was about the issue the certificates for the workers who wants to work in other country of EU. For example, a Lithuanian company would like to send some workers to the Netherlands, Germany, mostly Germany. Basically, it's largest labor market at the moment, and probably is so have quite a big request for the many professions like engineers or plumbers or constructors or something like that. That's why some Lithuanian companies would like to send some people by the Article of 12 or 13 to the German or Netherlands. But it is one problem. Dear colleague said about the significant activities in the main country. Yeah, it is really interesting topic for the many countries, especially for the so-called new EU countries like Lithuania, Latvia, and other countries. And it is so main question is normally, of course, out its activities there and who is posted. And to got the certificate A1 is important to have substantial activities in their own country, significant or substantial activities in own country, and that's the question for the court for court decisions. It was or not enough activity in Lithuania. The all cases was for the proving of was legal or illegal decision of Board of State Social Security about the issue or not issue the certificate A1. And the main question was about the part of the activities in their own country. And this question is regulated not only by the direct regulation of number 83, but it is can say that implemented rule by the decision of the director of the Board of Social Security Fund, and was decision about on the approval of the description of the procedure for the implementation of the provision, the regulation of coordination of the European Union social security system related to determination of the applicable law. This description gave rules for the companies who would like to get a certificate A1. And main question in the court was not about the question how long working the person in the company, how long working the company in the member state, but the main question is the activities, part of activities in Lithuania. Actually, before year 2010, actually that was a new regulation after 8 June of 2010, and before it was not clear what kind of part in Lithuania need to have some activities for the company to get certificate A1. And before the 2010, the Social Security Board have a practice that need around 50, that means 0.5% of the activities in Lithuania. That means maybe substantial part is so half, but later was decided about 10%. And now many companies got the certificates for the moving the workers to the different EU countries in case they have only 10% of the activities in Lithuania. For example, how I know Latvia have much better conditions for such companies that in Latvia needs only 5% of activity. For example, in Germany, it's different situation. It's need 25%, and maybe it's after year 2008, 2009, when it was the big so financial crisis in the world. In Lithuania, like in Latvia, we have many very high unemployment rate, and that's why it was one of the possibility to avoid unemployment benefits payment, and the workers can go to work in other countries by this possibility to get certificate A1. Not the not only for self-employed, but for the companies too. It was the possibility to give work for the many workers. And the 10%, it's the so in court decisions is was the main question it was 10% or not. And the companies and state social security board have different views about the counting of the 10%. Looks like 10% is almost nothing, or not so much, but it was used another one law. That means it was VAT law, VAT 12th article of VAT law. And that means what kind of goods was sold in Lithuania, but it's possible to sell for other countries. For example, if the goods was assembled in Lithuania or used in Lithuania, that's possible to got that 10% incomes. And for example, the regulation, 12th article of regulation, speaks not about incomes, about the activity in general. And Lithuania choose one of the so possibility to describe that activity. That means 10% incomes. It's not so difficult to know how big is income by the VAT declaration or also year-by-year declaration about incomes, and so it is easy to know for state social security board before the issue or not issue the certificate for the employers. And the parts in the procedure of court try to apply directly Article 12 of the regulation. And some parts try to say that in the regulation not described the 10% part. In the regulation, no, and this means the state cannot make so bigger requirements for the regulation than it is in regulation. But the court decided that 10% is probably not the object of discussion of it, or it is substantial activity or not, and that means 10% is stay in Lithuania like a description of substantial activity in Lithuania for the applying of the certificate. Yeah, and the counting of the incomes, it belongs for the sources of the incomes. That means the sources, firstly, should be from Lithuania. But, for example, if the company some assembling, some producing, and selling for the other companies in other EU countries, that in that case, such incomes, it will be calculated like incomes which was got in Lithuania. And what I would like to say, that mostly decision of the State Social Security Board is was legal by the court decision, and in some cases was decided that decision of the State Social Security Board was not clear about the point of the counting of incomes, the company. And So for me, exactly, actually was very so interesting that many EU countries use different different description of the substantial part of activities. It's actually it's between Latvia and Germany is difference 5 times. It's quite a lot, but probably is so can say that's not bad for example, for Lithuania, for Latvia to get some incomes to the social security fund in form of the social security contribution and tax payments and something and in place of the real immigration, because Lithuania have a big problem with the immigration, and for example in year 2009 immigration from the Lithuania was around 89,000 per year. That means in whole population was around 3 million people at that time, a little bit more than was, and 89,000 per 1 year in 2009. It was really too much, and probably the this rate, 10% rate, was so regulated to open possibility to move some people to other countries with the Lithuanian social security contribution and tax payments. So that's ground was for that decision, and the court still some cases about that 10%. Yeah, that's a short information about our practice in Lithuanian courts about the so you can say implementation of regulation 883. Yeah. Yeah. Thank you very much.
Thank you for your insightful presentation, Mr. Linas Vilys. And now everyone has the possibility to ask questions or comment on both of presentations. Yes, please. Yes, please.
So I think I will be the first one to ask. So I have 2 questions for both of the speakers, and just for the audience also be brave to ask questions, because there are no stupid questions. I was told that when I was a student myself, so don't be afraid to ask questions. And yes, there was a question. I cannot see that. Okay. Yeah, so I will start, and then there will be a follow-up. So I have 2 questions, as I mentioned before. So one for the Professor Hahn and another one for Mr. Linas Vilys. So for Professor Hahn, my question is, yes, you already gave us the picture what is happening right now, yes, on the previous regulation, how the case law is evolving, how the regulation is evolving. But I'm sure from your position as a professor and as a judge as well, I think you would be also able to predict a little what is the future of the social security in Europe, because in your first slide you mentioned like not full harmonization but only coordination. So is that the same principle still, or is it at some point evolving to some other direction? And for Mr. Linas Vilys, I would love to ask your opinion. Has anything has changed because of COVID pandemics in social security practice in Lithuania, or have you seen any changes in social security regulation, European or national, because of COVID pandemics. So these are two points I wanted you to elaborate. Thank you so much for your presentations.
Yeah, okay, thank you. One question, I think 3 answers. The first is, yes, you're right. As I told you, it's a very important process for the idea of a European Union integration process. Yes, European citizenship without without common basic social security principles will not be possible. But as I show you, the principle, the basic principle from the primary level is the Article 48, and as you saw there. There is a kind of stop in the primary level, and the stop is that any kind of harmonization is not allowed to bring the national social security systems in danger. Yeah, to bring any problems to the stability. For example, in Germany, it's a kind of constitutional good. Stability of national public insurance system is a kind of very important kind of a constitutional good, and so it is used as an argument to avoid any changes. And I think it's the same in every other member country. And so. From my perspective, at the moment, it's not be possible from a primary law level perspective to change the system completely into a full harmonized European social security system. And the second point you have to realize is that it's very close linked to political questions, because if you will change this, yeah, and there are some discussions on the European level. You could start some movement, maybe outside from the European Union. If you have a full harmonized European social security system, it would be very problematic for the not so strong financed member states, because we have a kind of nudge caused by different benefits in the member states to move to another country to demand the benefits there. Where is the best way to receive treatment, for example? And if it is completely open, if it will be completely open, it will be very hard for the financial stability for the members, for the member states where these people are coming from. And the other problem is under Article 70, as I told, we have the principle of application also for social benefits in the system of social as a basic income, and for the more stronger states, it would be maybe a problem that you influence a kind of movement, a kind of social tourism. You will lose their votes in any changing process. The third answer is, but this is only the perspective from the freedom of movement for workers. But we have a lot of other freedoms, for example, freedom of services. And as I realize it at the moment is that the change will come from this freedom, because you have to. It's not only the way to go abroad for working. It's only possible to go abroad to demand a service. And these directives for provision of services, they are quite more free. So the basic principle is you are completely free to go and receive services. There are only some limits for the payment. So maybe you're just reimbursed on the level as your insurance had to pay if you received the benefit in your living country, in your home country. But I think that is the way for little change. And yes, of course, the developing of law by the European Court of Justice. For us as law professors, it's a normal principle that the highest court is in the position to develop this legal system and bring new ideas for the integration process direct from the primary law. But that is also a very high criticized movement. Maybe it's the same in your country. I know it from Poland, for example, that this the way to developing European law, it's highly criticized. Yeah, as a kind of a competence, yes, from the European Court of Justice.
So I can just quick follow up. I think that it's more political question
Yes,
than
it's-
legal question.
It's a political and it's an economical question.
Yeah,
at
so
first.
I bet there are camps. Like
Yes.
there are some camps who are pro that
Yeah,
and who are against that. So
Yes.
yeah, but
Yes.
leave that for political
Yeah,
studies. Yes, thank you so much.
About the COVID situation and our experience, Lithuanian experience, I could say that probably we overcome some barrier in our thinking in the process of the COVID pandemic about the role of the state in the whole country life and the business life. That's mean in many countries in the crisis 2008 and 2009, for example, like in USA, was quite a big support from the state to the many companies to avoid bankruptcy of the big companies, and that was chosen a very interesting instrument that to buy the shares of the companies. That and in the start was the fund of around $1 trillion to support companies, and it was used around 750 billions for support. And finally, when the crisis was end, the shares was sold, and the state got a little bit more than $760 billion. That means it's depend from the measures for help for the business, and we don't saw the inflation in the U.S. after that crisis and after that support, because the money was input to the business. So it's quite a smart measure. And now in Europe was chosen a little bit different ways, but probably the situation was a little bit different. Not a little bit, but much different. And for me, that was actually surprising that state gave so big subsidies for the business, for the employees, and that was good. I think it was extension in our thinking, because before the COVID crisis was so I can say not the bright thinking about the state help for the business before the COVID crisis. Now we can know that state is important for the safe business, because in year 2008, 2009, and 2010 in Lithuania was so many bankruptcies that Lithuanian GDP was decreased around 35% in 2 years in general. That means the help of the state, the main lesson what we got in that last crisis.
So I believe we are not expecting the increase of bankruptcies in the nearest future in Lithuania.
Yeah, but we got another one problem about the electricity and natural gas prices, and another one problem will come together, the Euribor rate. That will be more impact to the households, and probably it will be not so easy, but actually better that life than life in war.
Thank you so much. So my first question will be, does the regulation 833 on social security cover protection of non-EU employees, like from Georgia, Ukraine, for instance, who work in EU member states? And the second question, in the case of posting employees from the EU company to a non-EU member country, for instance, Montenegro, are EU social security standards still applicable to these workers who are not in the EU because they were posted abroad? Thank you.
EU member state, or as a member state from the European Economic Area, or from Switzerland, or from UK, and if not, it's nearly the same principle. It's not important from where the worker was posted. So if you are a worker from abroad, maybe from, let me say, from Montenegro, it was in your example. If the worker from Montenegro moved to, for example, to France, as a first member state under the regulation, then the regulation will be applied, yes, but only for the situation in France. And if then later he moves to Germany or to Italy or anything else, then the principles from the regulation will be applied. We have some deviations from other principles. For example, if you have children, yeah, and you receive a child benefit, for example, in Germany, so I know they can receive it. It could be also paid if you live outside, but the reason is that is a kind of a tax reduction, and this tax reduction depends on the place of working. So if you're a worker in Germany, it doesn't matter where you are living. Yeah, so but that's the difference between the regulation and maybe other kinds of social security from other regulations. Yeah. Yes, yeah.
About the first question, first of all, it's important the migration law requirements for the people who is coming to EU countries from the third countries. For example, so between Lithuania and Poland, it is different requirements to get work permission or short living permission in Lithuania or Poland. And that good example with the people from a little bit earlier before the war, with the people from Ukraine. And it's easier to get work permission in Poland than in Lithuania at the moment. Later, when the company would like to send some such new workers from third countries to other countries of EU, then they should be got A1 certificate. The A1 certificate not valid for the third countries. That means we should know the regulation of the third countries about the decision of which law will be applied for the workers. That means for the third countries people, the regulation it's applicable for work in other EU countries. But for EU, for work in third countries, it's not applicable at the moment, and every time you should know the regulation of the third countries.
Thank you so much.
Maybe a little addition. Also, the European member states, most member states, I'm not sure it's the case in every member state, but they have also a kind of conflict law in their social security codes. So, for example, in Germany, in the Social Security Code 1, we have also conflict law for the question what is when if a worker from a third country comes into Germany, or from Germany you move to a third country. But these regulations are not applicable if the basic regulation is applicable. So you have to ask at first. You have to ask the question: is it a case where you can apply this? And if not, you have to answer it from a national perspective. Yeah, but that would not be a good solution in a common market. So of course, yeah, because of this, we have a common regulation.
Are there any other questions now or comments, please? Yes, please.
Thank you for your presentation, first of all, but also I would like to clarify that question of applicable law. For example, we have a lot of self-employed person, and what law should be applicable where the person will be covered by that social security? For example, if it's seafarers, who swimming under the flag of one member state, and for example, will it be covered by social security of that flag of that member state by the ship, or the country where it's have a residence? And for example, a self-employed person, it can have an employment contract in one country, in one member state, and temporarily live and working in another member state. Then what law should be applicable for that person?
First, the first part of the question, it was about workers working on the sea, or was it real? Really? Yeah. Okay. Yes. I didn't talk about this principle, but we have the flag principle also in the regulation. So if your ship is under a flag of a state, then it's a kind of being in the state. Yeah, that's the solution. Okay. So you're working on the ship with a Lithuanian flag, so you're in Lithuania for the regulation. Okay. Was it the answer? I hope. Okay.
Yeah. I just tried to figure out for real practice example how it's application, how it's work.
Yeah.
It's a good answer. Maybe I can make some remark in general, not only about Europe. For example, how the U.S. defends the cabotage shipment marked. That means in U.S. it's possible to deliver cabotage cargo only with ships who is registered in U.S. and not only, that means U.S. law, but not only, that ship should be produced in the U.S. It's so that could be do only U.S. It's probably not usable for EU, but it depends from the clients for the shipment with green requirements. That means the ships should be enough green to deliver cargoes in EU. For example, Sweden would like to have such services from the shipment when the ships is green. That means new, and usually new ships belong for the Netherlands, Denmark, and that means the protection of the EU marked is otherwise during the green green view, but the main answer, yes, it is depends from the flag. It's Netherlands or Dutch flag, Denmark flag. It's the main condition for the labor law or social security too.
Thank you for your answers.
Some other questions in the moment? So I do not see other questions in the moment. So then in this moment, I would like to thank Professor Hahn and Mr. Linas Vilys for their contributions. And with this, I would like to invite you to continue discussions in more informal way with some cup of coffee. And this is available only for those who are here on site. So we will say goodbye for those watching us online. Thank you for attention and for being with us. Thank you.